Hello, my beautiful. Welcome to 1111 True Crime. We're going to be doing a lot of talking through this, so if you're looking for just a straight read through, this is not it. um, I do feel that there are many that are not aware of the details of the Stephen Avery, Teresa Halbach, Brendan Dassey saga. And I would love to be able to dig deeper into that, and we will, but not tonight. Tonight, unfortunately, all I can say is that the judge has basically recused herself. Judge Suckthis, I'm sorry, I have a hard time with names and the pronunciation. It's Suckowitz. There it is. Suckowitz. Oops. I have some beautiful people that have been through this saga of researching this case with me over years, from 2016 on. Some of them were with me in the very beginning, and then some of them jumped on the Rubber Ducky channel with me. Hi, Nan's Life 7. How are you, my beautiful? Hi, Sherry. How are you? And Sassy. Cherish 63. What we're going to be doing today is we're going to be starting, because this is 57 pages, and I am going to break it down into as many parts as we need to get through it. But the deal is this. So, where do you even start? Let me get a can opener. I got to crack open this can of worms. And I want you to hear me out. So in the Idaho 4 case, yes, the Idaho 4 case, I have been with that case from the beginning. I am seeing a parallel, like deja vu, of what Stephen Avery went through that put him in a wrongful conviction situation of life in prison. Okay, I'm seeing a lot of similarities. So, in light of that, I've decided to combine my Rubber Ducky channel in a sense, because that was basically Steve Avery's case. And I broke down so many times that I felt that Scott T. and Bobby Dassey and Mike O. were the people we were looking for. And now it's been all these years later, and everybody's like, okay, I think we're looking for Scott T., Bobby D., and Mike O. And I'm like, okay, because I've been off the channel a couple of years, so you're caught up. And I don't mean to sound know-it-all-y or any of that. I'm just saying, you can only scream so much before you realize people are not ready to hear it. But the time is now. And this is going to be Stephen Avery's time. Everything in astrology, in tarot, is pointing to this being the big reveal. And the key was that Judge Suckthis has recused herself, and that was one of the main gatekeepers, and we've broken through. So what we're going to be going over today, hi Rose Hyde and Gemini 65 and Lorna, Seahorse Aquatic Swim School Ben, Jerk Ben, hello my lovely, and Robin Henson, everybody, hello to all of you. So I will be reading parts of it, coming back to chat. I want your input. Make sure if you have feelings, do not feel that I don't know this case and so I can't comment. Y'all, we're here to spread awareness. If you want to get caught up, this is your group, okay? There may be times where I am saying, see, this is what I'm talking about, how it's appearing in the Idaho 4 case to me. I don't know. This is a cold read. I'm going to mispronounce a lot of words. Feel free to do your English, grade me how I say it wrong and all that. I don't read those anyway. I'm not embarrassed if I say something wrong. So, knock yourself out. All right, with that, the Archer and the Empress, Tarot JG. Hello, my lovely. to you too. Free Ballin' is here. All right, we've got some core members here. We know it's going to get rewatched, so let's get rolling with this. The first thing we need to do is get this appellate brief up here and get you on the screen so we can go like this. So, this was actually filed with the Clerk of Wisconsin in January 12th, or on January 12th, 2024, and this is on appeal from the order denying post-conviction relief entered on August 22nd, 2023, okay? And this is basically a response to get more attention, right? And you're going to learn a great deal. Aw, thank you, Pre-Falling. Thank you. That was such a great snooper chat. Thank you for the $4.99. You're going to learn a great deal of how it's like there's a hidden blueprint in when they have a corrupt county or a corrupt state, okay? When the powers that be are corrupt, you can see a blueprint. The Ben Bennett case, the Finkel case, right? And then Avery case. And I'm seeing it again in the Kohlberger case. But let's go. So I will, when this live is over, I will go get the link for this. I will put it in the pinned comments below. And that way, if you want to rewatch, skip the commentary, and just hit where I'm reading it, and you want to follow through, you can do so, or just read it on your own. Page 6 of 57. That's why we're going to be in parts. Okay. Issues presented. Number 1. Before I start, can everybody hear me loud and clear if I just talk my normal voice and I'm sitting this far away from the mic? Give me a 1 to make sure on sound check that we're good. Ah, you guys, we have 33 in live chat. That's beautiful. Hey, Lorna Lovely, how you doing? Dog Mama's here. Hi, my loves. Soon as I see a 1, we'll go. I just want to make sure I'm loud enough. Thank you, Sassy. Number 1, whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief on its face because of the Circuit Court's failure to conduct on any such analysis as a matter of law. The Circuit Court answered no. Number 2, whether the Circuit Court improperly imposed a burden upon Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmund and Brady v. Maryland. The Circuit Court answered no. Whether the Circuit Court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence. The Circuit Court answered no. Statement on oral argument and publication. Pursuant to Wisconsin Statute 809.22, appellate requests oral argument to facilitate review of a complex legal issues raised herein. Stop right there. What she's saying is, we want to talk about this face to face. Okay? She wants an oral argument. A publication is warranted because a case is of interest to the public. All right, page 7. Introduction. When dealing with stakes as high as the defendant's liberty, third-party perpetrator evidence walks a bit of a tightrope. Without regard for Mr. Avery's liberty, even after he's brought forth strong new evidence connecting a third party to Miss Halbach's murder, the Circuit Court has denied Mr. Avery the opportunity for an evidentiary hearing. Mr. Avery now appeals the Circuit Court's denial of his amended third post-conviction motion because the Circuit Court's opinion is so legally and factually flawed that it does not even consider whether Mr. Avery has alleged sufficient facts to warrant an evidentiary hearing. Instead, The circuit court erroneously interprets State versus Denny as requiring conclusive proof of motive to satisfy the materiality requirement of State versus Edmonds, and as requiring the alleged third-party suspect to have the, quote, necessary skills to manipulate evidence in a manner that would implicate the defendant to satisfy the opportunity prong of Denny. So let's stop right there before we get too deep, because that's really, 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 really important. So what she's saying is they're putting the cart before the horse. The question isn't if there's conclusive proof that we have a suspect we can, put all the burden of guilt upon. We don't need to prove it. What we do need to show, and we've done that, is that this party, right, it brings in new exculpatory evidence to the case, period. Because in this particular case, the star witness was Bobby Dassey. The star witness was Stephen Avery's nephew. The star witness was the last one, allegedly, to see Miss Halbach alive. Now, we have affidavits that substantiate the claim that this so-called star witness that put Stephen Avery behind bars, if you will, in a manner of speaking, contributed. That star witness has been allegedly seen pushing the victim's car after her disappearance. I'm choking on the bullshit here. Why in the hell is that not considered new evidence? Because up until last year, we didn't know that? No one did? Okay? So, at this point, the state of Wisconsin saying, well, we really aren't going to listen to this case because, he probably was helping Stephen. He's probably an accessory to the crime. Excuse the hell out of me. We're not even at that level yet, sir. We'd still like to talk to you about the fact that if this is a star witness, it changes everything in the initial case. And so therefore, we need a second evaluation with the new information, just like the law allows. Okay, I got to get off my soapbox. Sassy, you are one of my biggest fans. I love you, darling. I love you. All right. I'll try to stay off my soapbox, but like I said, if this star witness allegedly is pushing the victim's car, we obviously need to go back and talk about this because we have some new information. And then we can talk about how, he could be biased and point the blame to another, and therefore his credibility would be gone, right? And then where would the case have been? Let's continue. The circuit court's decision denying Mr. Avery an evidentiary hearing on his new evidence of Bobby Dassey's, quote, Bobby's, possession of Miss Halbach's vehicle is based on an irrational premises, quote, that Bobby could have been in possession of the car that night to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime. First, the circuit court is hugely mistaken in presupposing that Brendan Dassey was ever linked forensically to the crime. He was not. The circuit court erroneously relies upon evidence that was barred from being considered at Mr. Avery's trial, such as Brendan Dassey's confession, to support its decision to deny Mr. Avery an evidentiary hearing. Stop right there. There is zero evidence of any kind. You name it. Name it. whatever kind of evidence you would like. In any case, any evidence, there is none, zero, against Brendan Dassey. So right there, that shows the court is full of bullshit. Okay. The circuit court speculation is that when Bobby Dassey, now remember, if you're newer to the case, Brendan Dassey is also a nephew of Stephen Avery, because Bobby Dassey is the older brother to Brendan Dassey. Bobby Dassey, star witness against his uncle Stephen Avery. Brendan Dassey sentenced to prison for life, okay, as an accessory with Stephen Avery against Teresa Halbach, basically. You know what I'm saying. The circuit court's speculation is that when Bobby moved Ms. Halbach's vehicle onto Avery property, it was his intent to help his uncle by hiding evidence. This is contradicted by the fact that all of the forensic evidence used to convict Mr. Avery was in the vehicle and was discovered because the vehicle had been moved onto the Avery property. Mr. Avery's blood and DNA was in the vehicle. Ms. Halbach's electronic devices from her vehicle were subsequently found in Mr. Avery's burn barrel, and the RAV4 key was later found in Mr. Avery's bedroom. None of this incriminating evidence was discovered until the vehicle was brought back to the Avery salvage yard by Bobby. In the circuit court's nonsensical conclusion, both these actions could be seen as an effort by Bobby to help Mr. Avery. He cannot be considered as a valid third-party Denny suspect. The circuit court failed to explain why, if Bobby was simply lending a helping hand to his homicidal uncle, he would then become the state's star witness against Mr. Avery. Okay, stop right there. My ears are ringing. Listen. How is Bobby Dassey helping his uncle by planting the vehicle as close to his uncle's home as possible? How is finding burned electronics of the victim in Bobby Dassey's burn barrel that's been moved over to Avery's property helping his uncle? How is being the star witness and lying and telling this story about seeing this victim walk toward the trailer, how's that helping the uncle? Nothing Bobby Dassey did helped or even looked like he was helping his uncle. In fact, it looked like he was transferring blame. Remember, he showered, right, after staring through the window for however long at Miss Halbach. What, did he get hot and bothered? Have to go shower before he went hunting? Remember Stephen coming out of the trailer after setting down the magazine? And poof, Bobby's gone, and so is Miss Halbach. Statement of the case and procedural history. Sheila Smoky, hi. Oh, I hope the judge is better. I hope so. Statement of the case and procedural history. This case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Ms. Halbach was reported missing on November 3rd, 2005. On November 5th, 2005, volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage and hold on. Let me start this over. On November 5th, 2005, searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked. Ms. Halbach had photographed vehicles at the site previously per Mr. Avery's request. According to state witness Bobby Dassey, Ms. Halbach was last seen walking toward Mr. Avery's trailer on October 31st, 2005. After finding Miss Halbach's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Miss Halbach's, Mr. Avery's, and Mrs. Halbach's blood in the RAV4, the remnants of electronic devices, and a camera, the same model as Miss Halbach's, in a burn barrel. Miss Halbach's RAV4 key in Mr. Avery's bedroom, with Mr. Avery's DNA on it. Mr. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by Mr. Avery's, quote, sweaty hands, and a bullet in the Mr. Avery's garage containing Miss Halbach's DNA. During Mr. Avery's trial, Bobby was the state's primary witness against Mr. Avery. The state used Bobby's testimony to establish that Mrs. Halbach never left the Avery property alive. In his opening statement, Prosecutor Kratz explicitly told the jury of the significance of Bobby's punitive observations on the date of Miss Halbach's disappearance. You are going to hear that Bobby was the last person, the last citizen that will have ever seen Teresa Halbach alive. My impression of Ken Kratz, all right? During the trial, Bobby testified that he observed Mrs. Halbach's SUV pulled up in his driveway at 2:30 p.m. on October 31st, 2005. Bobby testified that he then observed Miss Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Miss Halbach walking towards the door of Mr. Avery's trailer. The following exchange occurred between prosecutor. My nose is itching. I can't say his name. God help me. Give me strength. Kratz. Ugh, I'm allergic. And Bobby. Okay. Question. After seeing this woman walking toward your Uncle Stevens, did you ever see this woman again? Answer. No. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide, contrary to Wisconsin Statute 940.1, and felon in possession of a firearm, contrary to Wisconsin Statute 941.29. The jury found Mr. Avery not guilty of mutilation of a corpse. So, then who cut her up and buried her then, right? Okay, let's keep going. How y'all doing? Let me come up for air. Free Fallen says that key was planted along with his DNA, in my opinion. I agree. Gemini 65, I remember this so well when it happened. Y'all, I've been in this case so long that it literally, as soon as I start reading this, I feel like I feel I can walk the halls of that trailer. Like, I feel like I can walk it. It's weird. On October 11, 2019, Mr. Avery appealed the circuit court's denial of his second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. As this court's direction, Mr. Avery raised his claims in his motion to the circuit court as supplemental post-conviction motions. The circuit court denied his motions to supplement. During the pendency of Mr. Avery's appeal, a new witness, Mr. Thomas Zelinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Zelinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Mrs. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5th, 2005. Mr. Zelinski claimed that he had reported this information to the Manitowoc Sheriff Office. Surprise! All right. On April 10, 2021, Mr. Zelinski provided an affidavit to Mr. Avery's current post-conviction counsel stating that Mr. Zelinski was a motor route driver for Gannett Newspapers Incorporated and delivered papers to the Avery salvage yard in the early morning hours of November 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned on to the Avery property and witnessed two individuals, a shirtless Bobby Dassey, Bobby, and an unidentified older male suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Zelinski drove past the two men and delivered newspapers to the Avery mailbox, and then he turned around and drove back towards the exit. When he reached the RAV4 still over there, Bobby attempted to step in front of his car to block him from leaving the property. Mr. Zelinski came within 5 feet of Bobby, and his headlights were on Bobby during this entire time. Then Zelinski swerved into a shallow ditch to escape Bobby and exit the property. Mr. Zelinski states in his affidavit that he called out, "Paperboy, gotta go!" But he was afraid for his safety. He further stated that Bobby looked him in the eye and did not appear happy to see Mr. Zelinski there. After Zelinski learned that Teresa Halbach's car was found later in the day on November 5th, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office. What do you think they said, you guys? "We got the right guy already." I'll bet you, huh? What do you guys think? Hi, Tennille Ray. Welcome to 1111. How are you doing? All right. Are you ready? We are on page 12 if you'd like to catch up. I'm going to grab a drink, so I'm going to mute for just a second. Whew. Wet the whistle. Gets dry when I have to listen to this much, you know. I mean, really, honestly, Bobby Dassey was literally sinking his uncle's ship with every turn. Right? Who could have gotten that trailer past that dog, right? Who could have got past the dog? The big German Shepherd that the cops, the LE claim nobody could get near the place for so long because of the big dog, right? Who could have? Family member, right? Because Stephen was gone a lot, working, but the kids fed the dog, right? Stephen had cut his hand, and he said the sink was cleaned. Who could have grabbed the blood? Who had access to the car? Let's go. On April 12, 2021, Mr. Avery filed a motion for remand and a stay of appeal to the court containing Mr. Zelinski's original affidavit. On July 28, 2021, this court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claim raised in his 974.06 post-conviction motion and two supplemental motions holding the Avery 974.06 motions are insufficient on their face to entitle him to a hearing. So first they say you can't add it to what you already got. So you've already got a basket full of Brady violations over here and all this stuff. And now you're trying to bring two new things. No. You can't admin this and you can't add to it. Go make some new stuff up. Then the state says, okay, so now you're coming to us and you want this evidence to stand alone? No. Do you see how they want their cake and eat it too? That's called injustice. That's called, interfering with justice. Where were we? I read that so fast I don't even know where we were. It frustrated me. We're just going to pick up somewhere in here. However, the court did not remand Mr. Avery's case for a circuit court ruling on the claim in his most recent filing concerning the new witness, Mr. Zelinski, and reserved Mr. Avery's ability to raise this issue in a successive 974.06 motion. Specifically, the court instructed the following. As discussed below, we are not addressing Avery's most recent filing to this court, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 974.06 motion. That motion would need to survive both Escalona-Navarra scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the belly CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 974.06 motion, as all such issues would be for a circuit court to decide in the first instance. Well, how are we going to get to, second base if you won't let us get past first base? But you're saying, yeah, we probably have a big fucking problem here, but we're not going to let you bring in new stuff right now because you've already got some other stuff going. Listen, it's all a 974.06 motion. It's all the same damn thing. Get your head out of your ass. Start doing your math. Why the hell are you breaking up a bunch of bananas and calling them, well, we can't have these 3 bananas at the same time that we have this set of 2 bananas. And we're not going to allow you to bring all the problems at once. We want you to bring them individual, but they can't stand alone. Y'all, this case, I'm just telling you, it is absolutely where we are headed with the Idaho 4 Kohlberger case, in my opinion. It's a big circle effing jerk of injustice. These folks, alright, they hid the goddamn CD. The CD that showed that the Dassey computer that only Bobby Dassey would have had control of at the times that these searches took place, not only had the most repulsive searches, vulgarious, and very relevant to how Teresa Halbach died, but also DNA labeled file, Stephen Avery labeled file, and Teresa Halbach labeled file on the man's computer. Now we got him pushing her damn car, and the state won't even consider that maybe Bobby Dassey was setting up Steve Avery. Why would Bobby Dassey set up his uncle? Why? His best friend was Mike O. And there you have it. Let's continue to read. Regarding certain claims Mr. Avery raised in his motion to reconsider the Circuit Court's October 3rd, 2017 order denying his second post-conviction motion and his 2 supplements, this court found neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalona-Navarra or whether Avery pled sufficient materials entitling him to a hearing. Such consideration would have to come on a separately filed Wisconsin Statute 974.06 motion, and we express no opinion as to whether such claims would be barred in the event such a claim is filed. Therefore, this court did not rule on certain issues containing Mr. Avery's prior motion to reconsider and its 2 supplementals. Or supplements. How you guys doing? On August 16th, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to 974.06. Mr. Avery filed an amended motion on December 6th, 2022. Mr. Avery's 974.06 motion set forth newly discovered evidence that a third party, Bobby, was seen in possession of the victim, Miss Hallbach's vehicle after her disappearance. Mr. Zelinski contacted the Innocence Project about this matter in 2016. Although Mr. Zelinski originally believed it was Mr. Avery's trial defense attorneys that he contacted in 2016, after finding an email verification, he realized it was rather the Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion to stay his appeal to this court. And Mr. Zelinski's amended affidavit was filed to the circuit court reflecting this mistake. Affidavits from two other new witnesses in Mr. Avery's case, Mr. Kevin Ramlow and Mr. Thomas, and I'm going to say this wrong, but whatever, Burish, corroborate Mr. Zelinski's observations. In Mr. Avery's 974.06 motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Mr. Zelinski contacted Mr. Avery's current post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted its second public records request pursuant to the Freedom of Information Act, FOIA, for audio recordings of incoming and outgoing phone calls and or radio dispatches between November 3rd, 2005 and November 9th, 2005 relating to the case. The FOIA produced audio recordings did not contain the Zelinski call, nor did they contain any dates or times of the calls produced. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Zelinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the suppressed call to the Manitowoc Sheriff's Office on November 6th. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of its investigation, Mr. Avery's investigators then interviewed Mr. Zelinski's ex-girlfriend, whom he was dating at the time of November 5th, 2005 incident. Mr. Zelinski's ex-girlfriend, Devin Novak, corroborated Mr. Zelinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Mr. Zelinski's voice on the recording played to her by the investigator of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Mr. Zelinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Zelinski identified his voice in the audio recordings of the phone call from November 6, 2005. The recording of Mr. Zelinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. Pre-trial, trial defense counsel made two specific requests for all exculpatory evidence and or information within the possession, knowledge, or control of the state, which tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. Okay, let's stop right there. All right. So, this hide and seek and suppression of evidence by the state, why? Just ask yourself, why? What do they have to gain? In this case, let me tell you, it all boils down to a pissing match between the Attorney General of the state of Wisconsin, Peg Lautenschlager, right? And her pack of good old boys full of nepotism, beer and brats, right? Against a French boy. I believe this entire case started on a discrimination. I do. I believe the Good Old Boys Club, or as you want to, however you want to call them, I call them the bad boys, with power. The corrupt powers that be targeted him. They tunnel visioned him. We have a handprint on the back of that vehicle, a bloody damn handprint. On the back of the RAV4, still visible in evidence photos. Big, huge handprint. You know how much DNA is there? The state can't find enough to test it. Okay, Idaho 4. We've got 3 unidentified male DNAs. The state did not test it. Okay? It's called targeting. Why? Why are states willing to target individuals? It could be different reasons, but the pattern is there. The blueprint is there. The evidence gets manufactured. People, the witnesses, they get twisted about and turned around, and oh my golly, we have surviving roommates that are last ones to see the victims alive that are going to be the star witness in the Kohlberger case. Well, Bobby Dassey, in this case, was the last to see Teresa Halbach alive, allegedly, other than Steve Avery. And he was the star witness. Are you feeling me? DM is Bobby Dassey, you guys. In my humble opinion. But I'm not saying she did the crime. I'm saying the manipulation is there. You're either a star witness or you're an accessory. What one do you pick? Ask yourself that. If you were literally in a position where you literally are going to go down as an accessory or a star witness, and let me tell you, your family is vulnerable out there. Okay? That's how these gangstas of the corrupt powers that be tell you. You love your kids? Then you'll play this game. This is how they play. You love your life? You play the game. Things are going to go real good if you play the game. Let's get into this. Okay. I get frustrated. So the Archer and the Empress Tarot says they don't want to test that print because it's L.A. prints in her opinion. Well, or is it Bobby Dassey's? Or is it Mike O's? Right? If they're pushing the RAB, whose blood is that? All right, here we go. I don't know if I read this part, but we're going to redo it because I can't remember. No, I didn't read this yet. Mr. Avery's trial defense counsel prior to or during the trial. Let me wet my whistle real quick. Pre-trial trial defense counsel made 2 specific requests for all. I did read this. Pertaining to the Brady claims stemming from the evidence from Mr. Ramlow. Mr. Ramlow described in his affidavit that he reported his observation to a Manitowoc sheriff deputy he encountered on November 4th, 2005 at the Cynic station on State Highway 147 in Mishcot. No law enforcement report was ever generated by Manitowoc Sheriff's deputy memorializing the conversation between Mr. Ramlow and this deputy about Mr. Ramlow's observation of Mrs. Halbach's vehicle. Stop right there. All right, that right there should have told him it was Colborne because there's no report. Okay, let's continue. I just had to throw it in there. The circuit court denied Mr. Avery's motion for post-conviction release on August 22nd, 2023. Mr. Avery filed a timely notice of appeal on August 24th, 2023. This appeal follows. Argument number 1. Whether this court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief on its face, because the circuit court's failure to conduct any such analysis as a matter of law. In the circuit court's opinion dismissing Mr. Avery's third motion for post-conviction relief, the circuit court failed to consider Mr. Avery's request for an evidentiary hearing. The circuit court, quote, must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Only after an evidentiary hearing is the court charged with determining the issues, making findings of fact, and conclusions of the law. Wisconsin Statute 974.06. You guys, why is it that this defense lawyer, this post-conviction defense lawyer, is having to... y'all, my son's home, so he just got home from work. The dogs are going to bark a second. All right. Why... Hi, baby. I'm on live. I love you. How did work go? Okay. Why on earth is every one of these? What are we on? Page 16? 16 damn pages of this post-conviction lawyer having to let them know what the order of law is in court. Like, you have to have the hearing first, you guys. It's kind of like they want to just, it's so ass backwards. It's bass backwards here. Okay. Here we go. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume okay, we did that. All right. The circuit court improperly attempted to weigh Mr. Avery's facts with speculative theories unsupported by the record rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing, despite the fact that the circuit court opened its opinion claiming, quote, the defendant is back before the circuit court. The circuit court failed to conduct an analysis of whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Rather, in its opinion, the circuit court weighed Mr. Avery's evidence as if it had already been presented during an evidentiary hearing. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. The evidentiary hearing is a forum to provide allegations in a motion for post-conviction relief. Mr. Avery's motions for post-conviction relief states what he is set to prove if he is granted an evidentiary hearing. An evidentiary hearing would provide Mr. Avery with the opportunity to prove his pleas, claiming that he is entitled to a new trial. Avery's motion contained all of the proof necessary to show that he was entitled to a new trial. He would not need an evidentiary hearing. In Mr. Avery's prior appeal to this court, after the circuit court denied his second motion for post-conviction relief, this court properly was guided by the law for determining whether an evidentiary hearing is warranted. This court correctly stated the law, where, as here, a defendant appeals the circuit court's denial of Wisconsin Statute 974.06 motion without an evidentiary hearing, then the question before us is narrow, whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face. This court correctly noted the two potential standards for determining whether the circuit court erred in failing to grant an evidentiary hearing. The first being, the circuit court must hold a hearing where the motion is sufficient on its face unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief. This is a question of law reviewed de novo. Additionally, the court noted, quote, if the motion does not raise sufficient facts or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, then the circuit court has the discretion to grant or deny a hearing. In such a case, this court reviews an erroneous exercise of discretion. Here, the circuit court never conducted any analysis on whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing, nor made the requisite finding pursuant to State v. Jackson that, quote, the record conclusively demonstrates that the defendant is not entitled to relief. This court should reverse the circuit court's ruling denying Mr. Avery's motion because it failed to make the requisite findings established by case law. Number 2. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmund. This circuit court misapplied State v. Edmunds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Miss Halbach in the motion on his face in order to satisfy the materiality requirement of Edmunds. A standard of review. Okay, let's stop there for a minute. The fact that we have the new evidence, okay, that we have somebody pushing the vehicle in the first place is big. But for it to be the star witness now, allegedly, is pushing the victim's vehicle 2 days after she's gone missing, and then put all the blame on to the last person that ever saw Miss Halbach was my uncle. Okay, listen. We don't need to know why he did it. Stephen didn't have a damn motive. We didn't have to have a motive, right? The state didn't have to have a motive for Stephen. No motive. Why the hell do we gotta prove it? What the flying block? Maybe Bobby Dassey had a thing for him, being he had her all over his computer. How about that shit? And how about the fact that we're not even at that level? We're just trying to get our day in court so that we can be like, look, other people did this shit. We got them pushing the vehicle. The proof of the motive? That's when you get into Bobby Dassey's court time. Okay, just had to get that off my... This place pisses me off. This whole thing pisses me off. This is why I had to leave the AP case, and I can only come back into it in little tiny breaths. But right now, I know the divine is telling me we're about to get justice, and I've waited, and I've been patient, and so have you, and so have Stephen and Brendan. So, with that, let's keep going. A standard of review. You're behind in the live stream, Cynthia Caldwell. Well, sweetheart, you'll be able to go back and watch replay. I'm going to leave this up for everybody, even though I'm ranting through the whole thing. You're just going to have to get over me ranting or fast forward it. I can't help it. This case stirs it up. How long are we? We're into an hour. We're into an hour. Let's see here. Let's stop here. Let's take a minute. We're going to highlight this. All right. We will come back tomorrow night and we will read the rest. We've been in it almost an hour, and I want to chat with you guys. So we'll come up. All right. So whoa. Let me take a picture of this real quick so I know what page I'm on. Well, I didn't get the page number. There we go. Hold on, you guys. Let's grab this. We're going to start on page 18 for tomorrow night. It'll be late like this. Well, it might be earlier. It might be 6 or 7. I don't know. You're right, Sassy. Let's get into chat. Let's get off this for a minute. Pull this down. Go like this. And we'll just chat looking at the thumbnail. How's that sound? So Archer in the Empress Tarot says, Sassy, unfortunately, it seems it becomes the new norm. What the F, right? Tinley Ray says, be like the creek now, Boise boys, and speak to investigators through your lawyer. Sassy says, Stephen Avery had every reason not to do it, called $36 million. Ka-ching, right? Archer and the Empress says, keep going, honey. You guys want to keep going? We could. Give me a one if you guys want to keep going. I'm going to take an intermission then, because I've got a tinkle winkle. Alright, here's what we'll do. I'll put music on for you guys. Give me a minute. And we're going to consider this intermission. Sounds good? Okay, we're going to keep going. Yes, Avery is still in prison, my love. We're going to keep going. We're going to take 3 minutes, 3 seconds. And we'll come right back in. So with that, I'm going to leave you right here with the music, and I will be back. Alright, welcome back everybody. I'm back. Let me get comfortable here with you, and we're going to continue. So let's get that right back up on the screen. And we're going to go with a standard of review. Can everybody hear me okay? Okay. I may have to take this little jacket off. I feel like I'm getting warm. This case heats me up. It gets me frustrated. Hey, Jeff. Give you a chance to get your bowl? Well, get your shovel too, and your shit kickers. Alright. A standard of review. An appellate court reviews a circuit court's determination as to whether a defendant has established his or her right to a new trial based on newly discovered evidence for an erroneous exercise of discretion. A court properly exercises its discretion if it relies on the relevant facts in the record and applies the proper legal standard to reach a reasonable decision. Thus, the court will find an erroneous exercise of discretion if the circuit court's factual findings are unsupported by the evidence, or if the court applied an erroneous view of the law. Stop right there. So, what they're saying is, if you come to the court and it is, you bring a lot of bullshit, that it's stuff that, It's been hashed over before. They can reject it and be like, there is no reason for an evidentiary hearing. Okay? That is legit. They can do that. They can be like, that's nothing new. Go away. Come back when you've got something new. They can do that. But this isn't that. This is something that is absolutely, positively new. Not only that, but we have the Brady violation of the suppressed call to Manitowoc in the first place. Everything here. This is the standard that is set here is the law is being broken and stalled. And it's becoming to the point that I feel like we have American hostages locked up for life. Because even if these people were guilty at this point, even if they were guilty, we now have enough evidence to prove we would have other people that did it too. Why would the court not be pursuant of other people? I don't know. Oh my God, I can't. Okay. Burden of proof. On a motion for post-conviction relief pursuant to Wisconsin Statute 974.06, a defendant has the burden of proof. Wisconsin Statute 974.06, the defendant must show his entitlement to relief by clear and convincing evidence. And that's what affidavits are. We have 3 of them, right? To obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence. Okay, here's the criteria, you guys. Newly discovered evidence. The defendant must show specific facts that are sufficient by clear and convincing proof to demonstrate that. Number 1, the evidence was discovered after conviction. Correct. We got it. Number 2, the defendant was not neglected in seeking the evidence. Okay, we got that too. Number 3, the evidence is material to an issue in the case. Nailed it. Got it. All right. Number 4, the evidence is not merely accumulative. Okay? It's not like you got to add. No, this is big enough it can stand on its own, right? So we checked all the boxes. C, argument. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, the Zelinski evidence, but for the materiality required of Edmonds. The circuit court imposed a new Denny requirement. See, they're making up laws as we go. That Mr. Avery must establish that Bobby has a motive established by conclusive evidence to commit the murder of Miss Halbach to meet the Edmonds materiality requirement. Specifically, the circuit court said, a review of the record and the defendant's argument reveal that he has failed to satisfy the third standard of Edmonds. Hold on just Jeff. Do I have connection? I want to make sure I'm live still, y'all. Let me see what's going on. You guys, I don't know if we're live anymore. Hold on. Do I have the internet? Do I go through... Oh, there's my camera. Whoops. I'm in the wrong area. There we go. Well, it says I'm live, but yet I'm not 100% sure. I'm going to have to just hope I'm live. Hold on, you guys. Technical difficulty. I may just call it a night. That might be just simply what we need to do. Let me try and grab it. Yeah, for some reason, I'm showing I don't have internet, you guys. Like, completely. This is what happens on the Avery case when I try to cover it. Welcome to the old way. It says I'm live. Alright, you guys, I'm going to call it. Because according to one screen I'm live and one screen I'm not. And that's okay. We're on argument C, and I will screenshot it. Sorry I'm unable to see your chat, but I just realized I wasn't showing the screen anyway. There. It's time to call it for the night for me. I don't know what's going on with the internet. I love you. I thank you so much. I greatly appreciate you. And with that, my lovelies, I'm going to head out of here for tonight. If you would like to join me on the next live, we will continue this together. And, yeah, try and get some sleep, you guys. I'm going to try anyway. I love you. To the moon and back. And hey, if you didn't do the crime, you shouldn't do the time. I'm out of here.